Howdy and welcome to Criminal Justice in a Nutshell. My name is Dr. John Fisher, and today's episode of Criminal Justice in a Nutshell, we're going to be talking about plea bargains. I know we were talking about them last week in class, but I wanted to make a video on them. So plea bargains. Plea bargains is a invention of the court system to help the court system move more smoothly. Every courthouse, every courtroom, every judicial district has a backlog of cases. And the only way that they can go about making sure that we as a society have a legal system and people are facing justice for the actions that they take is through the plea bargain system. Okay, the plea bargain is an agreement between the state and the defendant, okay, where there's an exchange. In exchange for a guilty plea, there will impose a lesser sentence, a lesser charge. There are two specific kinds of plea bargains. There's the explicit plea bargain and the implicit plea bargain. The explicit plea bargain is the defendants will negotiate with the state for a charge reduction, for a specific sentence. The DA will not object to probation as being a punishment. Other specifications like incarceration in a local prison. You know, you can have the judge as part of a plea bargain, you can have the judge sentence you to serve time at French Roberts, which is just outside of Abilene, for your entire sentence, so that you're close to family, so that your family can come visit you and you can make a concerted effort to rehabilitation. We've found that isolating people from family is not a good thing. And when we're talking about domestic violence, isolating a person from their family is a symptom of domestic violence. And it doesn't help things, it makes things worse. So here we are. The implicit plea bargain is where the defendant is under the belief that the judge will be more lenient than a jury in sentencing him, and he goes to trial. So the defendant will plead guilty and seek the mercy of the court. And this is the way plea bargains work. Plea bargain is what makes the assembly line justice work. The courtroom work group, which includes the judge, the district attorney, and the defense attorney, will get together and they will work on a sentence. Okay. They assume that just because you're going to trial and you've been arrested, you're already guilty. So they make that assumption. That goes against everything that we believe in as a nation. As a nation, we're supposed to believe that you are innocent until proven guilty. With the plea bargain system, we throw that away and we just assume that you're guilty and we're going to find a punishment for you. So in order to get cases to run through the system as quickly as possible, people are encouraged to plead guilty for a lesser charge and a lesser sentence, with the threat that if you make this go to trial, we're going to seek the most severe mandatory maximum punishment allowed under law. Okay, so I had this case that I was working last year, and the defendant got caught in a sting operation. Is what happened. He got caught in a sting operation soliciting sexual activity with a minor, or whom he believed to be a 14-year-old girl. And they had made arrangements. They were going to smoke a little pot and they were going to go have sex. And this defendant had a 7-year-old and a 4-year-old at home, and he left them at home alone, which is why I got involved with Child Protective Services. But in his process, in his plea bargain, he was arrested for attempted solicitation of sexual activity with a minor and possession of marijuana. He tried to get the solicitation charges thrown out as part of a plea bargain. I'll plead guilty to the possession of marijuana You put me on probation for a couple years, and that'll be it. The defense attorney was using a defense of entrapment because this was not actually a 14-year-old girl. He was not actually talking to or trying to have sex with a 14-year-old girl, but a 44-year-old fat man from the police department. It was just his impression, and that didn't work very well. I think I've already shared the end result was that he, through the plea bargaining process, he's got 10 years probation, or 6 years probation, 6 years on the sex registry, and he lost his kids. He lost all parental authority on all parental rights to his children. But there have been people that have been for the plea bargain and against the plea bargain. And the plea bargain, I think, in my personal beliefs, the plea bargain, although it's necessary, because there's absolutely no way that every single person who gets arrested for a crime can have a jury trial. So, in order to save the expense of a trial and to save the time and money and make room for other cases on the docket, people tried to work the plea bargain. It becomes part of the process. It's essential. Nobody would ever have their day in court if we all waited for jury trials to come about. In the 2002 case, Santabello versus New York, the Supreme Court said and stated that the plea bargain is essential to the administration of justice. Okay, the plea bargain prevents a backlog of cases. I'm going to get to the criticisms and my personal criticisms here in a minute. But Santabello versus New York legalized and made the plea bargaining constitutional, and so because somebody had gone, Santabello took it all the way to the Supreme Court, saying that plea bargaining and forcing an individual to plead guilty is unconstitutional. Well, it's not. It is constitutional, and it can be done. But the criticisms, and my criticisms of the plea bargaining system, is it flies in the face of the Declaration of Independence. And it flies in the face of the Constitution. Okay, when we talk about why the United States of America became its own country, we look at how, let me back up. When we look at the Declaration of Independence, we hear that we went to war for our independence because of taxation without representation. We hear that all of the time. Taxation without representation is just one of 29 reasons why we were seeking our independence from England as our own country. And 5 of those reasons were judicial. They were not allowing us to be tried and have a jury of our peers from our own neighborhood. Okay? It had some person across the ocean 3,000 miles away determine what kind of punishment we were supposed to have. So, to turn around and make a plea bargain after the Declaration of Independence and after a war from 1775 to 1781, we fought for our independence. And, it was it was an amazing war. And just on a little side note, did you know that during the Revolutionary War of the United States of America, any slave that fought for the United States for 2 years, or I think it was 18 months, would automatically receive their freedom. and they would have received their emancipation from the United States government, and then they were free to go have their own family and all of that stuff. But anyway, that's just a side note. There's been a lot of talk about reparations here of late, and that come to my mind. But anyway, another issue is that the plea bargain negates the judicial protections found in the jury trial. Okay, and I've kind of said that. You're standing up and you're pleading guilty. You're violating the Fifth Amendment on your own, and you are pleading guilty for a crime that you committed. Well, that's just not very, it does away with the jury system. There is no jury that's finding you guilty. It gives a whole lot of power to the state, because now the state is, sentencing you. The DA, whose job is not to sentence you. The job of the district attorney is to show that you're guilty of a crime, not anything else. So anyway, the plea bargains are based on coercion, and the defense attorney is part of the work group who will fight and argue to ensure that you take the plea bargain, because it's easier for him. If you take the plea bargain, he still gets his money, and you go to prison. Okay. John Langbine is the most strenuous proponent of the plea bargain. He is concerned, and he believes, and I agree with him, that the plea bargaining system makes a mockery of the criminal justice system. But that being said, without the plea bargain system, where people who are guilty can get their sentence done quicker and quickly, they can get it done. They can just do it, and they can go to jail and get their sentence. That's why the judge has to ask you several times, are you guilty? Are you guilty? You have so many opportunities, and there's been some complaints, and even in the class, people have said, well, people are forced into pleading guilty even though they're innocent. The plea bargain system depends upon the strength of the defendant. If you are innocent of these crimes, you're going to fight it. You're not going to take a plea bargain. And that's the philosophy. The defense attorneys and everybody, they get real good at saying, hey, if you take this to trial, you're going to be found guilty, and you're going to be facing life in prison. But if you plead guilty, it'll be 5 years, and then you'll be done, and you'll be free again, and nobody really cares if you're a convicted felon. So that's the easiest way out. So a lot of people take that, and then they end up in prison. The plea bargaining system works when the people in the system make it work. Otherwise, it doesn't work. Hey, this is Dr. John Fisher. I've been filming from Lake Brownwood State Park in Brownwood, Texas. We're outside of Brownwood, Texas. I hope you have a good day and keep studying about the courts, because without the court system, we have anarchy.